one-man army. Is that what they call Gumite?
Chair, I can see Honorable Nsibambi with the FDC people. Are they presenting together?
He will tell us. He will tell us.
Kando.
So
PFA, no, FDC. PFF. Yeah.
thank you. Order. We will proceed.
Thank you, Chair.
30 minutes to Honorable Nsibambi, 15 minutes to present, 15 minutes to interact with you.
Yeah.
Thank you.
Thank you, Chair. I'm Yusuf Nsibambi, Member of Parliament, Mawokota County South. I'm presenting as a Member of Parliament, representing Mawokota County South, and a teacher of law for about 25 years. Yesterday, Honorable Chair, from morning to evening at 7, I was in the House before this committee. So I thank you for your kind permission for me to give my views. I've submitted the memorandum. It's just 4 pages. Actually, yesterday. Yes. Oh, yes. The committee works throughout the... Okay, before the clerk.
It was Friday.
I hope he has made copies, but if not, my presentation is going to be very brief. Honorable Chair and honorable members, first of all, apart from areas where I've highlighted as not adopted, I do associate myself with the bill in its entirety without modification. I also do associate myself with the memorandum presented before you by the Attorney General, which I looked at, except where I differ in this my memorandum. Mr. Chair, to understand the gist of this bill or any law, one has to look at the long title of the bill and also read the bill in its entirety, not just picking a clause and you highlight that as a problem. Under clause 1, Mr. Chairman, the bill outlines the long title with the following salient features: to provide for the sovereignty of the people of Uganda, to designate a department responsible for peace and security, and then 3, registration. There are issues of funding, which I've highlighted and I'll talk about under the long title. Mr. Chairman and honorable members, in a sentence, the bill creates a comprehensive legal regime for sovereignty, you can say integrity, of the people of Uganda. In the bill, you talk about defects, and many legal scholars and civil society are talking about existing laws, that this bill, in a way, it creates a crisis, this duplicity, that you have other laws, starting with the Constitution, Anti-Money Laundering Act, Terrorism Act, Political Organizations Act, and other laws. So that you don't need this bill, because there are laws prevailing which can handle the situations highlighted in the bill in the long title, which I don't want to believe, and I will briefly explain why. When you look at clause 2 about application of the bill, it is clear that this bill is not oppressive, but you really want to operationalize the Constitution. Article 1 talks about sovereignty, but you need a law to operationalize that. And we are saying comprehensively now we have a bill to put in force or the implementation of this particular article. And I'll go now straight to the interpretation clause. Mr. Chairman and honorable members, when you look at the interpretation clause, specifically clause 1 of the bill provides in this act, comma, unless the context otherwise requires. And this is here a uniform or standard opening clause for most acts of parliament. But I want to dissect it in 3 areas. First, when you look at this clause, it says in this act, you just highlight that one first. In this act, then comma, you also highlight the comma, unless the context otherwise requires. And this one covers the bill. It becomes now constitutional in this act, meaning the provisions highlighted in this act are meant to handle a situation. Then comma, the comma clauses, insulates the act. It becomes now comprehensive. It's not just an ordinary comma, otherwise there would be no comma. So in this act, we are talking about the Protection of Sovereignty Act. You have who is a sovereign, who is a foreigner, who is supposed to report, who has powers to regulate the minister in this act. So when you throw me to the Constitution giving you rights, it's wrong, because the act is specifically meant to handle the protection of the sovereign of Ugandans. That's why it's in this act, and then you have a comma closing. It's statutory interpretation. It's not an ordinary talk. If you have land and buy land, and you are not a surveyor, you are not in position to determine the extent of your ownership. You have to get a surveyor. If you are not a dentist, whether your kid suffered the whole night crying and you have a problem, you go to a dentist. So now the law says in this act. Now you look at the act first, which is meant to operationalize the Constitution. And then the comma insulates. So then, for the other laws you are talking about, which causes issues of duplicity, unless the context otherwise provides. So you now look at the context. If you now a kadama, I don't know, it has become sort of like in the UAE, and you're sending money to your sick mother, then you don't fall in this category because the context otherwise provides. Such an interpretation. So this business is saying that there are other laws. Those laws were specifically meant for that situation or purpose. I can just highlight on one law. This is called the Anti-Money Laundering Act, CAP 118. You look at the long title. Mr. Chairman, don't worry, I'll be under. The long title says, an act to provide for the prohibition and prevention of money laundering. Then it goes on, mid of the long title, in order to combat money laundering activities. Then lastly, used for money laundering purposes. Then the other line, preventing money laundering. So it's a law which was meant to control and regulate illicit activities. So when I send money to my mother for medical purposes, I don't fall under this category. Even if Financial Intelligence Agency is there to regulate the conduct of money transfers. But in the act, if that money is used to sponsor Bijambia, then in this act, and a comma applies unless the context otherwise provides. It's technical. Then, Mr. Chairman, I leave that one at that, but the total effect of the act is here to create independent and comprehensive legal regime for it to conform with the existing laws. Mr. Chair, again, when you look at Article 8A of the Constitution, I just read it briefly. Article 8A of the Constitution provides Uganda shall be governed based on principles of national interest and common good enshrined in the national objectives and directive principles of the state policy. Parliament shall make relevant laws for purposes of giving full effect to clause 1A, 1 of this article. Then when you go to part 4 of the national, of the directives in the Constitution, national sovereignty, independence, and territorial integrity, the state and citizens of Uganda shall at all times defend the independence, then highlight sovereignty and territorial integrity of Uganda. The state, highlight state and citizens of Uganda shall endeavor to handle national strength in political, economic, and social spheres. Then 3, the state shall endeavor to include, organize, and empower Ugandans, the Ugandan principle to build an independent and sustainable foundation. So it's my view that though Article 80 does not really specify what constitutes national interest, but when you read this together with the directives, it is clear that the state or government has the duty and the responsibility of creating a legal regime to protect national interest. So if there's interference outside, it can affect this particular principle. And it's Parliament which is vested with authority to make laws. So this business of you amend this, amend that, it is actually beyond, because now this all encompassing. It talks about so many things, and it's our duty and responsibility under the Constitution. Then, Mr. Chair and honorable members, they talked about the issue of citizenship. And this year it talks about even the context, unless the context otherwise requires. I just want to give a brief comment. The issue of citizenship is entrenched in the Constitution. It is entrenched. From Article 9 onwards, who is a citizen and duties of, up to 16, who is a citizen, and their different categories. It's not touched in the bill at all. The word foreigner should not be read ordinarily. I don't want to say literally. Like Oyomugwira. No. A citizen who becomes, when you become a citizen, and if there's any revocation, is determined by the Constitution. This bill is deeming a citizen residing out of Uganda for purposes of the Act. That's why they say in this Act, comma. The interpretation in this Act. So for purposes of sponsoring anarchy, if you go, for example, in a European Parliament, after elections, and you give a talk, you convince people that in Uganda there is chaos, the elections are not free and fair. And there's an electoral commission which is duly constituted to handle elections. And you have a process of dissatisfaction going to court. You don't go to court. And you didn't have a tally center even to determine whether you were robbed or not, or elections were rigged. But the European Union invites Ugandan officials, including an ambassador, with resolutions that please, the elections were free, not free and fair. To the extent of people now saying, we cannot invest in a climate where there's no democracy. Then you don't want to be touched. So the law says in this Act, because you did whatever you did outside, you were a foreigner or deemed a foreigner for purposes of implementing this Act, which is constitutionally the duty of government.
Chair, I'm sorry to interfere with the submission.
Conclude and you'll get.
Yes, I'm concluding.
Yeah, the issue where
prepare your question.
The issue where I don't agree with the bill, sir.
You will clarify on this one quite
The issue.
Honorable colleague, you conclude. Honorable Nsibambi.
I'm concluding. Thank you very much. Honorable Du, let me just conclude.
You have 2 minutes
No,
to conclude.
Yes, I have one actually.
2 minutes to conclude.
Okay, Mr. Chair, the only issue I have with the bill is the issue of sentencing
I think does not follow the guidelines set in our courts. Even the fairness is a little bit disproportionate, should be proportionate. I think it must be addressed. And then lastly also, the powers of the minister must be checked somehow. The issue of cabinet. So you must have an appealable, if the minister arbitrarily did something, where do you go? Then what constitutes government policy and public interest must be defined. The informal money inflows, I think I beg to submit, Honorable Chair. It's really a passionate thing, but we need this bill for the protection of our sovereignty, and I really request this Parliament, with those few amendments, I beg to submit.
Thank you, Honorable.
The first one, by way of clarification, when you narrated the scenario that took place at the EU Parliament, were you being factual or it is a fiction? And if you are being factual, does it then occur to us as a country that whatever transpired in the EU Parliament is what has annoyed the movers of this bill, and therefore they are targeting that person, that one person who went to the EU, and they want to punish the entire country by making this proposal for us? So I want you to confirm, and if you could give us more facts around it. Regarding what I followed, the EU Parliament at that time appeared to be concerned about the conduct of elections. You have mentioned the Electoral Commission. As a lawyer, are you saying that the recently concluded elections were actually very free and fair in Uganda here? Because that was the gist. The second thing I want to ask you is, how do you reconcile the concept of sovereignty, which is the power to govern, the power given to the state to govern the people of Uganda? How do you reconcile the fact that Ugandans have rejected? They say this is not sovereignty. You are purporting that you need this law to govern Ugandans, and Ugandans are saying we don't need it. So what is your, how do you...
We don't applaud in that manner with foot stamp.
Okay, Chair. Chair, the third is about his reliance on Article 8A, which he interprets twofold. One, that Parliament has powers to make the law, which is not in dispute, to further the national interest. I want to ask him, you single to us any national interest in this country that you think, first of all, is actually national interest and is not regulated, is not protected by any of the current legal regimes in this country. Can you single that?
Just before he came in, Imam Kasozi, a respected scholar and leader in the Muslim community, said this bill is against faith-based support, it's haram, it's against donor support, it prevents Muslims from receiving zakah, it prevents believers from going to heaven, its intentions are fraud. That is how he described it. Now, as a Muslim, Honorable Nsibambi, how do you feel going ahead with such a bill that has been described as such? Number two, Honorable Chair, there's information going around that actually this bill was drafted by Honorable Nsibambi during his interaction with the NRM chairman and the Attorney General. Honorable Nsibambi, how do you feel that a bill that was allegedly drafted by you is receiving all this hostility from the Muslim community itself, but also many sections of Ugandans. Finally, the other day I watched you on NBS with a former student of yours. And when you said, I am your child, he said, I regret. How do you feel that most of your former students are uncomfortable associating with you, not just on this bill, but on your current political ideas? Thank you, Honorable Chair.
Okay. Secretary Fox and Anna.